So what we're talking about is basically the difference between what's called a Standard First Regular DUI and a reduced charge, which is a wet reckless. A couple years ago, Marin County would not even offer wet recklesses, but in hopes of having less cases go to trial and realizing that, a .19 did not need to be treated the same way as a .09, the DA's office, the district attorney's office in Marin County finally agreed to start offering wet recklesses. So the two charges are very similar. Let me find my pen. So a regular DUI is DUI is vehicle code section, and this is in California, 23152. Okay. Wet reckless, we'll just call it a wet, is vehicle code section 23103.5. So the difference, there are a number of differences. In some cases, they don't make big differences, but for others, they can make a huge difference. The wet reckless is priorable. This is a similarity. So if you got another DUI within 10 years of the arrest of your first one, and then the first one was turned into a wet reckless, the new DUI within 10 years would count as a second DUI. Okay, that's a similarity. That's their main similarity. Penalty-wise, though, there are some big differences. And this is why a lot of people would prefer to have a wet reckless. One of the main differences is the maximum penalty on a DUI, and this would be what you could get, the biggest jail sentence if you lost at jury trial, the judge thought you were lying, they want to throw the book at you. I mean, that's really one of the only circumstances where on a first DUI with no accident, you would get a maximum sentence, and they're so rare. But the maximum sentence is 6 months. On a wet reckless, the maximum sentence you can get is 90 days. Okay, big difference there. So that is something to understand. So what that basically means is that if you're put on a probation, which almost everyone who gets convicted of a DUI is, and that's from 3 to 5 years, in Marin County, the wet reckless probation is almost always 3 years. In some other counties, such as San Francisco or San Mateo or Alameda County, they may do a lesser probation on a wet reckless, as low as 18 months, sometimes 2 years. But in Marin County, it is 3 years in almost every DUI and wet reckless case. And so during that 3 years, if you violate probation, you get in trouble for something else, you don't do what you were supposed to do, what these numbers mean is that if you're found in violation of probation, you can get a hearing with a judge, and that judge would make a determination on how much of the 6 months or how much of the 90 days on a wet reckless that you would need to serve. So those are again, differences. Now, fine-wise, let's talk about that. A DUI is typically on a DUI is usually about $2,000, give or take a little bit, in Marin County. A wet reckless will be under typically $1,000, and so that's cost-wise a difference as well. Another difference, which is a big deal, is in regards to how the DMV hearing comes out. So on a regular DUI, the conviction will trigger a suspension with DMV in Sacramento. The court sends proof of conviction to Sacramento. They'll send you a letter saying, you're suspended for 6 months. You can get a restricted license or an interlock license or jump through these hoops and do these things. And then we're also facing the administrative per se hearing with, if it's a Marin County case, it's usually San Francisco DMV. And there's a separate suspension process there if we're not able to win it. And typically, if you're not winning in court, you're going to get some type of a suspension, whether it's a restricted license or an interlock license or whatever it is. With the wet reckless, though, if we can win DMV, all right, and that is huge, win DMV, then equals, this is the great part, no suspension of your driver's license, which is huge. To get arrested for a DUI, to be over the legal limit, and to walk away from that with no suspension at all is a very big win for most people. It should be. And have we been able to do that before? Yes, many times over the years. In Marin County, typically they will consider a wet reckless after negotiation if you're at a 0.10 or lower for your breath or blood alcohol tests. If some of the tests are at a 1.1 or higher and some are at 1.0 or lower, they're still not, it's nothing's definite. Negotiation has to happen. A lot goes into it from your attorney presenting to them. But in Marin County, if we can get a wet reckless and if we can win the DMV hearing, no suspension. Now, that doesn't happen all the time, doesn't happen most of the time, but it does happen a lot in my office, because what we're often dealing with DMV cases are things like rising blood alcohol levels. We're dealing with blood tests or breath testing that may come back, say at an 0.8, and then we've got some great arguments there showing that, the third digit, a margin of error could put someone under an 0.8, and there's a lot of real good case law that helps us fight these cases and save the license. So maybe there was something procedurally or probable cause issues that, helped us get the DA to get the case down to a wet reckless, might also work or might only work at DMV to get the administrative per se hearing turned into a dismissal. And if that happens, then no suspension. So you can get some, great results when you have a lower alcohol level or there are deficiencies in a case. It can help us fight it, help us negotiate it. And this is one of the many reasons why a wet reckless can be a really, really good thing. Now, if we get a wet reckless, you don't need to, and if we can beat the DMV, you don't need to get what's called SR22 insurance, and that's high-risk insurance. So you don't need to pay extra money and maintain it for 3 years like you would if you didn't win DMV or if you got a regular DUI. So another place where a wet reckless can be huge, because that saves a lot of money. Other differences between a wet reckless and a DUI. Let me see if I can erase some of this. Some additional differences between a DUI and a wet reckless. For a DUI, they will often give you a certain number of days on the sheriff's work program. You may get credit if you were in custody for 1 or 2 days, but typically in Marin County, they want a minimum of 2 days, sometimes more. If you have a prior DUI that's more than 10 years ago, they'll add on 5. If you weren't in an accident, this is kind of their rough formula, they'll add on 10. They can really add it up and we've got to whittle away at that with our negotiations. If we can't make the case go away on a suppression motion, or if we're not going to win at trial or go to trial, then it's negotiating time. On a wet rec list, though, this is great. Typically, they are asking for 0 days. And when I say days, that could be either done in jail, or what most people are eligible for is doing the sheriff's work program. In Marin County, it's called the Adult Offender Work Program, and basically it's run through the probation office, and you'd sign up for it. You'd have a phone or in-person appointment with probation and work out the days that you're going to do, and then you would do them, either under the guidance of the sheriff, or they'd send you to someplace like Goodwill in San Rafael or Novato, and you do something like sorting clothes for however many days you need to do that, and then you would have to do one more thing, which is show up at the what's called room C24, which is the sheriff's room, to do a rebooking on what they give you as a surrender date. That surrender date would be to show proof that you've done your work program. And if you don't have that proof, then you'd actually have to do jail time and surrender on that date. But everyone who does this properly, we walk them through this, and probation does as well when they meet with them about the work program, is usually able to not have to go back to jail, because going there once is more than enough. Another issue with the wet rec list is, and this will depend on how the DMV hearing goes, is on a regular first DUI, we've got what's called a 3-month or 32-hour DUI school. On a wet rec list, typically what's required is a 12-hour DUI school. Now, big difference there. That's 20 hours. That's a lot of time. If we're not going to be able to beat the DMV hearing, the administrative per se hearing for a Marin County DUI, then what will happen is, if you want to get a restricted license, you're going to need to do the 32-hour or 3-month school if you got a wet rec list. Okay, so sometimes the wet rec list is not just the 12-hour, but instead you might have to do the 32-hour. It depends, and so you need to know that, and that's something that we always go over with our clients when we're discussing different options. You can either if you get a wet rec list, do no driving for 4 months if you don't win your DMV hearing, or and no driving for 4 months in the 12-hour school, or you can do the 32-hour school and have either a work-restricted license for 3 months after 1 month of no driving, or do 4 months of ignition interlock. Whereas if it were a DUI, you'd have 6 months of ignition interlock if the alcohol level is not over a 0.20, and typically just the 32-hour school. I'm not going to get into DUIs and elevated DUIs and how long the schools are. Just the thing to know is that you've got 12-hour or 32-hour depending on a wet, and typically on a regular DUI it's at 32 hours, and they add on another 30 hours if you have to do the 9-month DUI school, or another 30 hours. So cost-wise, that's something people want to know. Typically for the 32-hour DUI school, it's close to $700, and for the 12-hour, it's, I want to say, less than half that. And they let you typically do a few monthly payments. Now, something that is really important to know is what's going on with these 12 or 32-hour DUI schools.